This hearing is in the matter of case number CFI 09A-2021 before Justice Roger Giles. The hearing is being held by way of video conference at the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Clyde & Co. Lead counsel is Mr. Nicholas Craig. The defendant is represented by Holman Fenwick, Willen Middle East. Lead counsel is Mr. Gregor Hogan. Thank you.
Yes, thank you. Yes, Mr. Hogan.
Yes, the two applications. The first is the jurisdiction challenge under Article 5 of the JAL and RDC Rule 12.1. The second is an application to strike out the claim under Rule 4.6 Sub-Rule 2 on the basis that it's an abuse of the court's process. I rather suspect that the first of those applications is going to take up more of the court's time today. The claim form itself, is for your note, is at page A6. And your lordship will have gathered that the substantive dispute here relates to two marine insurance policies, and your lordship will also be aware that that's not a category of dispute or a type of dispute that regularly comes before this court. The claim itself, as you've gathered, relates to the disappearance of a vessel known as Beta from UAE waters. Your lordship will have gathered the background from the two witness statements filed on behalf of Horizon from Mr. Al-Sari and the witness statement filed on behalf of ABNIC. The two policies themselves under which the Beta was insured were a marine hull / machinery policy, and that's at page A23 for your note, and a marine hull war policy, which is page A27 for your note. The background, I think, in dispute really relates to the timing at which various events took place, in particular the notification of the disappearance of the vessel, and informally, and when formal claims were made, or on ABNIC's case purported to be made, in relation to the disappearance of the vessel. And those events took place between roughly December 2019 and October 2021, which is when a formal claim notice was made under the policies. And then subsequently a claim was made to the Onshore Insurance Authority under the auspices of the federal insurance law. Broadly, it's Horizon's case that the vessel disappeared, and that's covered by the policies, and their claim in the onshore insurance before the onshore insurance authorities for a payment of $70 million US. ABNIC's case is that the policies are void ab initio for material misrepresentation. Alternatively, in the claim form, they seek a negative declaration as to liability on the grounds of avoidance of the policies. Or finally, they seek various declarations that the loss does not fall to be covered by the policies at all. In light of the ongoing and extant proceedings before the Onshore Insurance Authority, which have now been escalated to the dispute resolution committees established under Article 110 of the Federal Insurance Law, which I'll take your lordship to in due course. It's Horizon's case. This is a classic example of a conflict of jurisdiction. And in our case, the Onshore Insurance Authority, insofar as it's relevant, was first seized of the dispute. And we say that goes to the abuse of process argument that I've come to later in my submissions.
Well, you use the word onshore quite a bit in your submissions. What do you mean by onshore?
My lord, I refer to the federal jurisdiction of the UAE civil courts. Under the Onshore Insurance Law, which applies throughout the UAE, excuse me, in relation to onshore risks, there is established an insurance authority. I should say that's recently been absorbed into the central bank of the UAE. The insurance authority was then tasked by legislation to create various dispute resolution committees. Those dispute resolution committees deal with the resolution or adjudication of disputes and complaints arising under insurance policies. Those resolutions then need to be enforced in the onshore courts, and under the insurance law, the courts identified for that purpose are primarily the Abu Dhabi and Dubai courts, but Horizon's cases they could also apply to the onshore courts in the Emirate of Sharjah. So when I refer to onshore UAE, I'm referring to the whole of the UAE, save for the DIFC and the ADGM.
So you're really not talking about a difference between land and sea or anything like that. You're talking about something else?
Well, there is obviously the point that the insured risk here could never obviously have been in the DIFC as a landlocked jurisdiction. But when I'm referring to onshore,
anywhere on land, could it?
Quite, my lord. Well, I suppose not in any waters of the DIFC. But when I refer to onshore UAE, I'm referring to the regulatory regime, which we say is mandatory in relation to onshore insured risks and to policies of insurance written onshore. Our position, Horizon's position, I should say, is that that regime is mandatory for insurance written by onshore insurers, and there is no ability to opt out of the jurisdiction, firstly, of the insurance authority and the IDRCs, and then laterally the onshore civil courts when you come to either enforce those resolutions or appeal them or challenge them. The language isn't entirely clear. If you don't like the decision ruling handed down by the IDRC.
All right, well, but let me then understand, you just referred to onshore insurers. What are you referring to there? In other words, what is not an onshore insurer?
Well, perhaps I could take your lordship to the insurance law.
I want to understand your use of the language, because that's a tad confusing in your submissions. What do you mean by an onshore insurer?
An onshore insurer is an insurer regulated by formerly the insurance authority, now the central bank. And who can write insurance onshore is defined by Article 24 of the insurance law, which I can take your lordship to if you wish, or you perhaps prefer to read it later. An offshore insurer is one regulated by the DFSA or the ADGM, but I'll focus on the DIFC. And under the free zone law.
Sorry, so the distinction you draw between onshore and offshore is that onshore is what you might call Emirati, offshore is DIFC or AGB, being the carve-outs of the common law jurisdictions. Is that the distinction you're drawing?
Yes, my lord, and the reason I draw it is because Article 4.4 of the 2004 Financial Free Zone Law creates a unique exception to the general exclusion of federal civil and commercial law in the DIFC, insofar as it provides that in relation to insurance within the UAE, the only insurance activities that can be carried on in the DIFC is reinsurance in relation to onshore risks and onshore insurance. And in my submission, that's a unique and very important, in this case, carve out from the otherwise general exclusion of federal and civil law in the free zones, the DIFC and the ADGM.
Well, if the distinction is between the Emirates in general on the one hand, they're onshore,
yes,
and
my lord.
DIFC or the ADG on the other hand, and they're, in the language you use, the opposite of onshore, namely offshore, then I will try and follow that language.
Well, that's my submission and the distinction that I seek to draw.
Right. Okay.
My lord, the only basis for jurisdiction of this court and advanced by ABNIC in this case is Article 5A2, the opt-in provision. And so there's no assertion here that ABNIC or Horizon are or have been DIFC establishments, so that the policies were negotiated or transacted within the jurisdiction of the DIFC. The jurisdiction clauses, for your note, are pages A25 and A29 of the bundle. They're in identical terms. I quote that each party agrees to submit to the exclusive jurisdiction of the courts of the UAE. So it's a form of jurisdiction clause which has been considered by the courts on a number of occasions in this jurisdiction. I should point out that there is a reference to an arbitration contract in the jurisdiction clauses in the policies, but it's common ground between the parties that no effective arbitration agreement was ever reached. So it is a court-based jurisdiction clause. That's a common ground, as I say. My lord, you'll see that my learned friend and I rely on almost the same authorities, and all those authorities will be well known to your lordship in relation to the construction of jurisdiction clauses. The wording of Article 5A2 will also be very familiar to your lordship. It's set out in both my own and my learned friend skeleton arguments for ease as well. It's at page B3, paragraph 8 of my skeleton. And of course, there is a specific requirement that the any jurisdiction clause conferring jurisdiction on this court is specific, clear and express. At the outset, I should say that, as I say in my skeleton, I make no bones about the fact that the authorities have made clear that the phrase courts of the UAE or similar courts of Dubai can mean and include the DIFC courts. But my submission is that crucial in that analysis is a proper contractual construction and a process of construction of the clause and the words in question, such as to determine whether an active choice has been made by the parties to confer jurisdiction on the DIFC courts. And it's my submission that the courts of the UAE can, but does not necessarily mean that the parties have chosen to submit their disputes to the jurisdiction of the DIFC courts, as opposed to only the onshore courts. It's also established that it's for the person asserting that there's been a choice to adopt the jurisdiction of the DIFC courts or to adopt a particular jurisdiction to prove that. That was made clear recently by Justice Martin at first instance in Goyle, and that was upheld in the Court of Appeal. I think at a high level, the parties' respective positions on jurisdiction can be distilled into the following. As I say, it's Horizon's case that the court should consider the position of these specific parties as well as these specific policies. And once that process is undertaken, it's perfectly clear that these parties and these policies have no connection at all with the DIFC. And in fact, the most obvious jurisdictional connection between these parties and these policies is to the jurisdiction of the Emirate of Sharjah. And in my submission, various, I'll call them objective factors that are identified by ABNIC in relation to the policies, for example, that they apply English law, they're in the English language, etc., which they say point to the jurisdiction of the DIFC. I say they're largely neutral in the overall analysis. ABNIC's case is, or appears to be, and I hope I don't put any words into Mr. Craig's mouth, is that there is effectively a de facto presumption that the words courts of the UAE amount to a DIFC choice of jurisdiction unless contrary indications can be identified and the lack of any connection to the DIFC is irrelevant, and that here it is imperative of real importance that in relation to marine insurance policies that they are enforced by, quote, an international, end quote, court because they incorporate standard clauses based on English laws and decisions, and because the DIFC applies law very similar to English law, and because ABNIC says the onshore courts do not, and again, quote, generally, end quote, apply foreign law such as English law. So although I wouldn't say that the parties are approaching it from the opposite ends of the telescope, I would say that the starting points between the parties and the emphasis they place on different parts of the case law is different. My Lord, I think it's common ground between myself and my learned friend that English law principles apply to the construction of the jurisdiction clause because the agreements, the policies are expressly governed by English law. There's authority. I've included a passage from Dicey, Morris and Collins at page D265 if your lordship wishes authority for that proposition. Now, my Lord, I don't wish to take your lordship through each of the various authorities that are in the bundle, which will be well known to you because they've recently been considered in two decisions of the Court of Appeal. But I would have liked to take your lordship just through those two most recent decisions, the Goyle decision and the Labika decision, because in my submission they set out clearly and authoritatively what the test to be applied is. And those two decisions were decided by the same Court of Appeal as constituted by the Chief Justice, Justice Shamlan Al-Swahili, and Justice French. So if I could take your lordship first to the Goyle decision, and that's at page D116 of the bundle.
I have a hard copy, so refer to paragraphs, please.
Yeah, so of course, my lord. In that case, the Court of Appeal was considering the phrase courts of Dubai in the context of an agreement to which one of the original contracting parties was a DIFC establishment. So straight away one can see there a quite clear connection between the contract and the parties in the DIFC. Subsequently, the contract was assigned such that the party jurisdiction was lost, and therefore the jurisdiction clause in favour of the courts of Dubai became the only way in which the DIFC courts could have jurisdiction. At paragraph 89, my lord, I'll give your lordship an opportunity to turn that up. One can see there, excuse me, I'm just getting there myself, that the Court of Appeal held that when the term the courts of Dubai, and in my submission that could be applied equally to the courts of the UAE, is used in a contract, the ordinary meaning absent context and purposes pointing in a different direction refers to all the courts of Dubai, or insert all the courts of the UAE. Now, that might suggest some sort of presumption in favour of DIFC court jurisdiction, but in my submission, if one then looks at the next paragraph, the Court of Appeal is making quite clear there that one is just dealing with ordinary principles of contractual construction, and there is a separate and secondary question in each case as to whether or not the words used are sufficient to enliven Article 5A2. That's the word that enlivens the word that features in both the Goyle and the Labika decision. So I don't dispute, and Horizon doesn't dispute, that as a matter of constitutional fact or political reality, the DIFC courts are courts of the UAE. But my submission is that that's a different question as to whether the particular phrase is to be construed as a choice, an active choice of the DIFC's, the jurisdiction for resolving the parties' disputes. And in my submission, what was absolutely central in the Goyle case and to the conclusion the court reached was, as I say, that initial status of one of the contractual parties as a DIFC establishment. So the court at paragraph 92 noted to the fact that that original status would have conferred automatic jurisdiction and exclusive jurisdiction under Article 5A1 of the JAL. And so the court held that that might be said to mean there was a technical but unnecessary opt-in to the jurisdiction of the DIFC. And to the extent that that would have required an answer, the fact that one of the parties was a DIFC establishment was central to whether it could be distilled, and it could be distilled that the parties intended to submit their disputes to the DIFC court. But that question only became relevant when the question as to the parties' intentions only became relevant once the contracts had been signed and party jurisdiction was lost. And you can see at paragraphs 94 to 95 that the Court of Appeal found that no such change in the parties' intentions had occurred on the facts, and there was no need for reinterpretation of the parties' intention at the stage at which the assignment took place. The parties hadn't changed their jurisdictional horse. And indeed, at paragraphs 97 and 98, the Court of Appeal said that there was, quote, no red flag of constructional choice, end quote, because there was no ambiguity in the phrase courts of Dubai at the outset. But the very reason why there was no ambiguity was because one of the parties had been a DIFC establishment. So there was a clear pointer in favour of the jurisdiction of the DIFC court. And indeed, the Court of Appeal made clear at paragraph 100 that, quote, the history of the transactions in this case is central to the contractual construction. Sorry, the constructional conclusion, rather. So in Horizon submission, the Goyle decision simply confirms that, as a constitutional fact, the DIFC courts are courts of the UAE. However, that such phrases and words can be ambiguous, and that on each occasion, the words used need to be interpreted to determine objectively what the parties agreed, and whether they agreed that there should be jurisdiction conferred on the DIFC courts, regardless of the fact that the DIFC courts are politically and constitutionally courts of the UAE. Now, the Labika decision, which should be the next one in the bundle, that's the very recent decision from the very end of last year from the Court of Appeal. Now, that case involved a loan agreement which contained a jurisdiction clause, again in the form Courts of Dubai. And if your lordship looks at paragraph 39 of the judgment, one can see that, unsurprisingly, the very same Court of Appeal relied very heavily on its earlier reasoning in the Goyle decision. And again, we can see at paragraphs B and C that it was the specific lack of ambiguity in the particular circumstances of Goyle that was considered important and key to that decision. And the question of jurisdiction is always one of contractual construction, and the transactional history was, quote, central. Now, the Libika decision, we say, is an outlier in the sense that there does appear to be no apparent links between the parties and the DIFC. But what we say is, if one looks at paragraph 42 of that judgment, the Court of Appeal makes again very clear that the surrounding circumstances will be important, particularly where they point against the Courts of Dubai, meaning a choice to confer jurisdiction on the DIFC courts, and that constructional indications to the contrary must be considered, and that the words and phrases Courts of Dubai and Courts of the UAE can be ambiguous in the particular context and therefore not specific, clear or express.
Paragraph 42 does rather tend to suggest that prima facie, a phrase such as the Courts of Dubai will be sufficient as a choice of jurisdiction unless there are indications to the contrary.
I agree, my lord, but there has been some.
Position.
There has been some commentary on the Libika decision, which has suggested it's moved the dial very firmly in one direction. And in my submission, what the Court of Appeal in that case was doing was distilling the reasoning in the Goyle decision and summarising it. And I can't dispute that it's concerned primarily with indications against the courts of the DIFC, but my submission is that that's only an extension of what was previously decided, in the sense that where there is no ambiguity at the beginning, obviously one needs to deal with contractual indicia to the contrary, but that is presupposing that there is, on the particular facts of any given case, no ambiguity. And in the Goyle case, that was obvious because one of the parties had originally been a DIFC establishment, so there was an obvious link between the DIFC and the particular parties and the particular facts of the case. In my submission, what paragraph 42 and the various questions posed rhetorically in that paragraph is simply drawing out the fact and making clear that it's the process of contractual construction which is key. And in my submission, the first instance judgment of Justice Martin in Goyle, which was upheld on appeal, is very clear that it's for the party asserting that the courts have jurisdiction under a jurisdiction clause to establish that. It might be that there's some sort of evidential burden which shifts, or legal arguments have to be made against a starting point of DIFC court jurisdiction on the facts of particular cases. But in my submission, all the cases, other than perhaps Libika, the reason why the phrases Courts of Dubai and Courts of the UAE were found to give rise to a choice of DIFC court jurisdiction is because there was a pre-existing link between the particular facts of the case and the jurisdictional clause. And I've set those out. And indeed, in the Libika decision, one can see at the very end of the judgment that the Court of Appeal noted that the parties had given evidence, or I should say the appellants had given evidence, because of course in the Libika case the respondent didn't appear, so there was no one running the argument that there were contrary constructional indications. But the Court of Appeal did take into consideration that the parties had subjectively considered that they were agreeing to a jurisdiction of an English language court. So one could argue that there was, on the evidence as found by the Court of Appeal, as established, that there was a link again to the DIFC, because the DIFC is the only English language court in Dubai. But in my submission, if one looks at the previous leading authorities in this area, which were assessed and summarised in the Goyle case, so Suntec, Talim, IGPL, as I've set out in my skeleton at paragraph 14, in each of those cases, there was some other link to the DIFC. Even in opt-in cases, either the court had found that the underlying law was DIFC law and therefore it was, quote, inherently improbable, end quote, that the parties would have disaggregated choice of law and jurisdiction, as in the Talim case. And in the IGPL case and the Suntec case, either one of the parties was a DIFC establishment, so there already was party jurisdiction, or alternatively, the transaction had involved a DIFC establishment or had been conducted in the DIFC. So you had either Article 5A, 1A, B, or C jurisdiction. So the case that Labika is, insofar as Labika is a case in which there was no link to the DIFC, and as I say, the Court of Appeal did in fact find one on the evidence presented to it, but I accept that the principles of interpretation there may have been different insofar as subjective intentions could be taken into account. I say Labika is an outlier. It's factually distinguishable from all the previous cases which have involved some sort of link to the DIFC, which could be taken into account as part of the contractual construction. So, my lord, unless I can assist you any further on the authorities, I wasn't planning on spending any further time on the authorities of the specific test which have been set out in Goyle and Labika so recently.
Yeah, well, they say what they say. So.
They say what they say, and I'm sure Mr. Craig will address you further on them in due course. So turning then to the facts of this particular case and applying those principles to it. Horizon says that there is no choice of DIFC court jurisdiction in the jurisdiction clauses in question, for broadly two reasons. The first is that we say the parties here have first absolutely no connection whatsoever to the DIFC or the Emirate of Dubai, or no relevant connection to the Emirate of Dubai, and rather all the contractual indications and circumstances point to Sharjah being the obvious choice of jurisdiction within the phrase courts of the UAE, and is obviously the jurisdiction with the most substantial and closest connection to the parties and the policies. And secondly, we say that the structure of the federal insurance law and insurance law and regulation in the UAE means that the overall context and purposes of this transaction and these policies are taken as part of the factual backdrop, mean that these particular parties could never have considered the words courts of the UAE to mean a choice of the DIFC as a jurisdiction for the resolution of their disputes. So taking the first of those broad headings, at section E of my skeleton at page B7, I've set out the various factors which demonstrate the lack of any link to the DIFC and the overwhelming links to Sharjah. So first, my lord, Abnick and Horizon were at all times operating out of offices in Sharjah. So one can see page A21 to A22 of the bundle that is a translation of Abnick's business license, and one can see at the bottom of the page there, reading from right to left, address line, there's some Arabic, and then Sharjah. And Mr. Al-Sari, who gives evidence, sorry, my lord.
Go ahead.
Was that? Yeah, sorry. And Mr. Al-Sari, who gives evidence on behalf of Horizon, his evidence at page A15 of the bundle is that Horizon's operations in relation to these policies were all conducted out of its Sharjah offices, and that in reality that's the main centre of its business. He says at the time the policies were executed, there was a minimal skeleton staff in Dubai, and in fact now there is no actual office of Horizon in Dubai, has no employees there at all. In relation to personnel who work in marine insurance, faced with the overwhelming documentary evidence in my submission that the parties were at all times working out of their bases, ABNIC has produced, in Sharjah, ABNIC has produced 2 lists of marine insurance workers, it says, work at its Dubai offices. Those are at pages A103 and A105 of the bundle. We say, my lord, that those lists take your lordship no further forward. ABNIC has not sought to identify which of any of those employees actually worked on any of these policies. ABNIC doesn't identify what sorts or volume of marine insurance work they undertake in Dubai. And ABNIC has produced, crucially, no evidence that Horizon was aware that any of these activities occurred in Dubai. Mr. Al-Sari's evidence is that Horizon considered the only relevant insurance conducted by ABNIC through its Dubai offices was in relation to car insurance. And again, at page A15, at paragraph 7 of Mr. Al-Sari's witness statement, he's quite clear that from Horizon's perspective, it was dealing with a Sharjah-based marine insurer when it took out the policies with ABNIC. Now, ABNIC has taken place some reliance on the fact that Horizon is incorporated in Dubai, and it said in their witness evidence at page A88, paragraph 12, that was what parties considered to be a link between the parties and the policies and Dubai. But again, my lord, there's simply no contemporaneous evidence that ABNIC placed any reliance on that fact, or that it even considered Horizon's limited physical presence and staff in Dubai to have any part in negotiating or concluding the policies, or that Horizon's place of incorporation was discussed between them. There's some emphasis placed on the fact that in one of the policies, the address for Horizon is listed as its Dubai address. In my submission, that's entirely unremarkable. If a company is formally registered in a particular jurisdiction, it's quite common for its registered office to be listed on a formal document such as a contract of insurance. And in fact, in relation to one of the policies, no address is listed at all. So in my submission, there's clearly not much importance placed on it. And as your lordship's aware, there are many companies in the UAE that are formally incorporated one emirate, but conduct most or a great deal of their business in another emirate, and really have no connections with the emirate of incorporation. And indeed, that's Mr. Al-Sari's evidence in his second witness statement at page A200, paragraph 7. Indeed, it's accepted by ABNIC that, in fact, in order to serve the claim form, they sent an email very shortly before they did so to Horizon, asking it to confirm its Dubai address. In my submission, that demonstrates that ABNIC knew fine well that any address maintained by Horizon in Dubai was potentially or very likely to be a formal one only, arising from Horizon's purely technical and historic incorporation there. And ABNIC knew that it had nothing on its files that would provide any actual working address in Dubai, because it always dealt with Horizon in Sharjah. Indeed, there was no need for the address in Sharjah to be confirmed, because they knew very well what that address was. So in my submission, that simply demonstrates the fact that the overwhelming connections between these particular parties and these particular policies to any jurisdiction within the UAE was to Sharjah. And then there are the discussions leading to the conclusion of the policies. It's taken against me that these discussions are inadmissible as an aid to construction under English principles. I would say that that's a misapplication of the particular rule. And I say that because I'm not seeking to rely upon the content of the discussions between the parties leading to the conclusion of the policies to identify what they understood the courts of the UAE to mean subjectively, or to establish some sort of common or private dictionary between them. Rather, what I say is that the place where the relevant staff and employees of the parties were based and from which they sent emails and formal documents to each other is a relevant factor, an objective factor that would have been identifiable by the reasonable third party in the shoes of the parties at the time of concluding the contract. And again, I say that assists the court in demonstrating that any connection with any jurisdiction in relation to these policies and these parties is overwhelmingly and exclusively with Sharjah. At page A40 of the bundle is an email
Yep.
Sent on the 28th of June 2018 from Mr. Salab, who gives evidence on behalf of ABNIC, to Emilda Rama, who was an employee of Horizon. And what one can see there is in his email signature, Mr. Salab's address is listed as being at 6000 Buhaira Tower, Khalid Lagoon in Sharjah. And his telephone numbers there conclude after the international prefix 971, the number 6, and that is the local dialing number for Sharjah. So that in my submission, it's quite clear that these negotiations were taking place between, at least on the one hand, from Horizon, from ABNIC in Sharjah. And if I can then take your lordship to page A106, which is an email that is relied upon and was put in evidence by ABNIC.
Yep.
We can see there a response from Ms. Rama on the 10th of June 2018, or it might be first in time actually, and one can see there in her email signature that she's writing from the insurance department office with the telephone number, again with that number 6, demonstrating that she is working from Horizon's offices in Sharjah. And if I could take your lordship to jump back, and apologies for jumping around, to page A25.
Yep.
One can see there, that's a page from the Marine Hull and Marine Insurance Policy. In the top stamp, just under the authorised signature, is in slightly unclear text because it's obviously been photocopied. One can see there that it's been stamped by the Sharjah Marine Insurance Department of ABNIC. And there's a similar stamp at page A29 on the second insurance policy. And I should note that in the 2 lists of employees I referred to earlier on, those have in fact been stamped again by the Sharjah Personnel Department of ABNIC. And it's Mr. Al-Sari's evidence that, and I don't think this is challenged, that all the policies were sent in hard copy from ABNIC's Sharjah offices to Horizon's Sharjah offices. So my lord, the bottom line is that no discussions about these policies have taken place anywhere other than within Sharjah, between the offices of the parties in Sharjah and between employees and personnel of the parties in Sharjah. So in my submission, those are important constructural indications pointing against a choice of the DIFC as a jurisdiction within the phrase courts of the UAE.
If one is doing this interpretation exercise, one has to say, ask not just what is excluded, but what it means. So what do you say the phrase means? In other words, what courts do have jurisdiction?
In my submission, it is at the very least the onshore civil courts, and by that I mean potentially limited to the Abu Dhabi and Dubai courts by the terms of the insurance law. But my instructions are that as a matter of federal law, it is possible to take your IDRC decision and enforce it in a local court, a more local court, so the Sharjah court. So in my submission, here this would mean the Sharjah courts, because those are the courts in onshore UAE with the closest connection to the parties. But if one looks at my recollection of the CPC is that it is possible to sue a defendant in the place of their incorporation. So I can't exclude the possibility that a local onshore court in Dubai would find that it did have jurisdiction to hear a claim against Horizon.
It's not a case of what that court might find. It's a case of what, on your submission, the construction of these words means.
In my primary
Emirates of Dubai, what courts do you say that is? Is it all the courts of the Emirates, what, in your phrasing, the onshore courts? Or is it only Sharjah, or what?
Well, in my submission, my primary submission is that it's the Sharjah courts that's having the closest connection to the parties and the policies.
Well, it does seem a rather large step to interpret words of the with courts plural of the Emirates as meaning only one emirate.
You broke up slightly there. Did your lordship say there was a large step to interpret the courts of the UAE as Sharjah only?
Yes.
My lord, I accept that. But on the other hand, if a clause was saying the courts of the UAE was an exclusive jurisdiction clause, and the courts were to follow the logic of Labika and say that that automatically or prima facie meant the courts of the DIFC, in my submission that would lead to the same result. That's a very narrow and depending on what you
it doesn't mean that it's only the courts of the DIFC. It means that any of the courts, onshore or DIFC or ADGM, that's the ultimate construction that Mr. Craig is going for.
Yes, my lord, I accept that. But my submission is that all the indications here, all the contractual circumstances, is that the courts of the UAE means the onshore courts. Sorry, because there are only onshore courts. The civil law courts in Sharjah. That is my submission.
I understand that, but one has to ask, if one is carving something out as a matter of construction, from the general words, courts of the Emirates, at least to me, you have to ask, why is one carving out the DIFC only, or is one carving out every other court? And if so, other than Sharjah, and if so, why?
Well, in my submission, I don't need to, in my submission, get home on it only being the Sharjah courts, because
you do, because you have to make sense. You have to tell me what your construction is. There has to be a positive, not a negative.
Well, when I come on to, I can take your lordship to now. When one looks at the broader legal background established by the insurance law, it's perfectly clear that at the very least, the courts of the UAE must have been understood by the parties to mean, at the very least, all of the onshore civil federal courts. That is the background against which they were contracting. There may be a dispute, as there often is, between ABNIC and Horizon as to which of those courts are the correct courts, and there is, as I understand it, a question of interpretation of the insurance laws to whether or not it is possible to challenge or enforce an IDRC resolution and decision in a court other than the Abu Dhabi or Dubai courts. But at the very least, when one considers that mandatory regime in relation to onshore insurance, and in my submission is that that is mandatory because of the express carve-out in the financial free zones law, then it must at the very least mean the federal courts onshore. In my submission, I don't need to get home on Sharjah.
I wanted to know, however, what your position was.
And I would say that it's
because if one points to all the things which one says mean the closest connection is with Sharjah, then one has to say, well, why does that mean does that mean any court other than Sharjah is carved out? And if that is so, why do you pick on the DIFC courts?
My lord, I've just received a virtual a post-it note. Could I just have 1 second just to read my WhatsApp? My instructions are that under the insurance law, you can appeal. Perhaps I hope I have not misled your lordship. My instructions are that under the onshore insurance law, it is possible to appeal a decision of the insurance authority to any of the onshore civil courts. So in Sharjah, that would only be the civil courts, as there's no offshore, and not just Abu Dhabi and Dubai. So in my submission, it is the local courts. My primary submission remains that it is the local courts of Sharjah, which means the courts of the UAE in this particular context, given the insurance regime that exists and against which the parties contracted. And in my instructions are that although they're not publicly available, Horizon's investigations reveal that there are hundreds, if not thousands, of claims being pursued by ABNIC in the Sharjah courts. So in my submission, given the insurance regime, which I'll come on to talk about, it is perfectly possible to construe, and indeed it's the only proper construction of this jurisdiction clause, that the courts of the UAE meant the local Sharjah courts.
Okay, well, there's a lot of slipping and sliding between one and the other here, but I hear what you say.
Well, I think that may have been a misunderstanding on my part, and for which I apologise.
But hang on a second, Mr. Hogan. If it be right that one can appeal a decision of the committee under the Emirati legislation, the federal legislation, to any of the onshore courts, using onshore in the way you do, then that would suggest, if I understand your argument correctly, that the phrase must mean any of the onshore courts of the Emirates, not just Sharjah.
With my submission, it would be any of the onshore courts which would have jurisdiction against the particular defendant. And under the CPC, in relation to ABNIC, if Horizon was seeking to enforce the decision of the IDRC, that would have to be in Sharjah, because that's where, as I understand it, it's incorporated.
Oh, I understand, right. I see that step in your argument. Okay, thank you.
Apologies, I was my misunderstanding of the insurance law, so I apologise for that. So my lord, those are what we say the sort of micro level facts, which we say not only point against the phrase courts of the UAE, including the DIFC courts, but which we say, and I apologise for not having made this clear at the outset, which we say go to a positive choice by the parties to submit their dispute to the Sharjah courts, because that is the jurisdiction onshore in which ABNIC would have to be sued in relation to enforce a claim under the insurance policies.
Yep.
So my lord, taking the sort of more macro level analysis, perhaps if I could just take your lordship through some of the steps in relation to the insurance law that I've been discussing. If I could take your lordship to page D 227.
Yep.
That's Title 3, Chapter 1 of the Insurance Law number 6 of 2007, and Article 24 addresses the point your lordship made at the outset, which is the persons who are entitled to conduct insurance and reinsurance activities in the state. The state's defined as the UAE. But of course, under the free zone law, reinsurance activities can take place offshore, so that's a carve out. but it's by persons who are licensed and registered with the authority, that now having been merged into the central bank. So we say that's the only persons and in the only capacity in which onshore insurance can be written. And I apologise for using the word onshore, but it is possible to write insurance in the DIFC in relation to DIFC risks. So, for example, in relation to a building in the DIFC, insurance can be written in that sense. And if I can take your lordship then to D 210. That's the free zones law.
Oh, yeah. That's just.
And over the page at D211, you've got 3.2, well-known and broad exception of federal civil and commercial laws from application in the free zones.
Yeah.
But then the Article 4.4 is an extremely important carve-out to the carve-out, so to speak, which is that the carrying out of insurance in the state, i.e. within the UAE, shall be restricted to reinsurance. And then if I could, sorry to keep jumping around to D275.
Just give me a moment. I'm swapping between some hard copy and some online stuff. Yes.
This is official guidance from the DFSA's website, and under the large print summary, in the rather small print, it said there that insurance firms authorised by the DFSA are permitted to conduct only regional and global reinsurance business in or from the DIFC. And then over the page below the very final bullet point, the third bullet point, again, the guidance is that given the UAE Federal Law number 8 of 2004 requires insurers in the DIFC to conduct reinsurance only for risks situated in the UAE, the insurance markets in the DIFCs evolved primarily into a reinsurance market. And sorry to jump around again, but if I can then take you to D242.
Yep.
Perhaps I can.
Yeah.
That's our Article 1110, yes. And what one sees there from Article 110.3 is that claims relating to disputes from insurance policies, activities and services may only be accepted. That's by the onshore courts or the local civil courts after the bringing of these disputes before the committees formed according to Clause 2 hereof. So in my submission, Article 110 contains a binding method of dispute resolution, which is a necessary and integral part of litigation in relation to insurance contracts within the UAE, save insofar as it relates to reinsurance conducted in the DIFC or the ADGM under Article 4.4 of the Free Zones Law. And indeed, more recently, there has been a carve-out of that jurisdiction introduced in relation to arbitration, whereby the dispute resolution committees established under Article 110 will not have jurisdiction to hear claims where there's an arbitration agreement. But that carve-out has not been extended to situations where the parties have entered into a jurisdiction clause in favour of say, a first instance court in the UAE, thereby avoiding the IDRC preliminary stage, or in favour of an offshore court or a foreign court altogether, thereby avoiding the whole of Article 110. So,
can you refer me to that? Because when you say they can avoid 110, I thought your position was you couldn't avoid 110.
My submission is that you can only avoid it through a arbitration agreement. And sorry, I'm just going to find the relevant provision. If I can come back to that in a moment, because I'm going to have someone virtually sitting behind me. I don't have the reference at the moment to turn to identify that for me. I'll take your lordship to it in a moment. Excuse me while I just ask for that. As I say, Article 100, the insurance law was very recently amended to create a specific carve-out in relation to arbitration agreements, but in my submission, the fact that that's had to be expressly carved out, and there was a choice only to include carve-outs for arbitration, indicates very strongly that in relation to court proceedings, there is no ability to opt out of Article 110, whether in relation to the preliminary insurance authority / committee process, or then by way of enforcement or appeal or a challenge. I'm not quite sure what the correct terminology is, appeal or challenge to the committee's ruling in the local civil law courts. So, my lord, we say that.
I'm sorry, can we just go back for a second? You say to the local civil courts, is that Article 110(4)?
Yes, that's 110(3), where it says that a claim can only be brought after there's been a resolution, and that means enforcement in the civil courts, or appeal or challenge in the civil courts.
Well, why does one limit that to claims only in the civil courts?
In my submission, because the DIFC court, the DIFC has no jurisdiction to engage in any activities relating to insurance, onshore insurance. And in my submission, that the DIFC courts are an integral part of the judicial apparatus of the DIFC, and therefore it too can't have jurisdiction as a court under this law, because the DIFC court cannot engage in the regulation and enforcement of insurance policies written onshore. In my submission, in just the same way that the Court of Appeal in IGPL found that it could not be contrary to UAE public policy, that the CPC did not apply and was disapplied by the DIFC court, because Article 3.2 of the Free Zones Law amounted to a positive public policy decision to create a separate civil and commercial legal regime in the DIFC. By the same logic and the same reasoning, the specific exclusion, the only specific exclusion in relation to civil and commercial matters of insurance activities in the DIFC, means that there has been a decision of public policy that the regulation and enforcement of insurance policies and insurance disputes can only be conducted onshore. In my submission, the DIFC and the DIFC courts can't have it both ways. Where there is a specific and express exclusion of all civil and commercial laws, it is a matter of public policy that the DIFC applies its own civil and commercial laws. But where the federal government has expressly and uniquely carved out insurance from the DIFC's activities and what can legally be conducted in the DIFC, In my submission, the DIFC courts too have to respect that public policy choice. And the correct way to do that is to interpret Article 110, 3 and 4 as conferring only jurisdiction on the relevant local civil law court.
Is the result of that the DIFC courts or no doubt DGM courts cannot decide any insurance disputes except possibly a dispute about insurance of a building in the DIFC?
Or disputes arising from reinsurance, which can be in relation to onshore, or insurance in relation to foreign, i.e. non-UAE primary risks. That's also permitted because the state is defined in the free zone law as the UAE, and in Article 24 of the insurance law as the UAE. So a DIFC insurer could write primary insurance in relation to a building in London. It just can't write one in relation to Jumeirah, for example.
Why can't could a DIFC insurer write insurance over a vessel in an ocean anywhere?
In my submission, it can't do that if the primary insurance is being conducted onshore, in the sense that the insurance is being offered to an onshore party, that being Horizon.
So you are taking as your criterion the location of the insured rather than the location of the risk.
I think that must be the logical logical destination of my submission. Yes. If the
Destination.
Sorry, excuse me, my lord. What
is that the correct destination?
Well, I think that must be right.
Doesn't leap out to me as being correct.
Excuse me, I've just received a. My instructions are that and therefore my submission is that neither an onshore risk, in the sense of a physically located onshore risk, or an onshore insured can be insured on a primary basis through the DIFC or by a DIFC insurer. It needs to be conducted through an onshore regulated and licensed insurer, and under the auspices of the insurance law. That's my submission.
How does that apply to this case?
Well, in this case, the insured Horizon is onshore. It's incorporated in Dubai.
Even though the risk is offshore in a different sense. You say the connection, because Horizon is onshore in the sense that you use the word, is enough to mean what? Could not be written in the DIFC. What does that mean? It's written in Sharjah. So what's that got to do with DIFC's jurisdiction at all? Why does it
in my submission, and if you, I've just been pointed to a particular provision, so if you would indulge me if I take a second just to My instructions are that the wording of Article 24 of the insurance law at page D227 in relation to where it says any insurance activity in the state, i.e. in the UAE, can only be conducted by those three types of persons, legal persons, licensed and registered with the insurance authority, now the central bank. And my instructions are, my understanding is that insurance activities covers any insurance either related to onshore risk or in relation to a party, legal or natural, who is domiciled in non-free zone UAE, so outside of the DIFC or the ADGM, but in the rest of the UAE. That's my instructions, is insurance activities is broad enough to cover both insurance of onshore risks and onshore insured. Those are my instructions. Perhaps if your lordship will indulge me, I may come back to you later on this if I want to have been able to consider it in more detail while I'm listening to Mr. Craig. But those are my instructions, and that's my submission at this point.
Well, please be assured that I'm not being deliberately difficult, but I am having trouble following some of your points, and my questions are with the intention of trying to understand better. But on your case, Buhaira is caught by Article 24. It is exercising an insurance activity in the state, or it was doing so when it insured these risks.
And when it insured Horizon as an onshore, as a UAE non-DIFC, non-ADGM incorporated and domiciled individual.
On one view, that doesn't matter a damn. If it is carrying on the insurance activity, it could have been insuring a London domicile company for a risk over a Mongolian domicile building.
Well, if it was
the criteria exercise the insurance activity.
That's my understanding is that is correct, that the insured in that case would be able to come to the UAE and would be able to rely upon the exclusive jurisdiction of the insurance authority and the IDRC. And my lord, that breadth of jurisdiction is not uncommon as a matter of UAE civil law. Your lordship is well aware of the sorts of arguments advanced by litigants in relation to the conduit jurisdiction, that the conduit ought not to apply to them because they are domiciled onshore, and therefore the UAE courts have prima facie exclusive jurisdiction to hear any dispute in relation to them. This breadth of claimed jurisdiction is not unusual in my submission as a matter of UAE civil law. then in the example you've given, if there was an exclusive a jurisdiction clause in favour of the courts in England, if the parties may well choose, ABNIC may not choose to dispute the jurisdiction of the English court, and everyone's very happy to proceed there. But in my submission, the effect of Article 24, given that it is an insurance activity carried on in relation from the UAE, even if it's in relation to a London owner of a Mongolian property, would prima facie fall within the exclusive and mandatory regime of the insurance law.
It seems to me that your argument does come down to this very simple one. Buhaira was carrying on an insurance activity within the state. It is therefore caught by this insurance law. Being caught by it, Article 110 applies to it. It requires it to process the insurance claim according to the legislation in force, etc., etc. Isn't your argument that simple?
Yes, my lord. I think your lordship is.
And then on jurisdiction, you say, and because of that, that is a factor for saying the only courts with jurisdiction on the proper construction of the clause are, it seems to me, inevitably you must say the onshore courts, but not the DIFC.
Yes, my lord. I think you've teased out. Yes, my lord. You've teased out the core of the submission and put it more clearly than I did, for which I'm grateful. That I think if one stands back and ignores the technicalities of the insurance law and considerations, then yes, that is the crux of the submission. Is that this was related to an onshore domicile, a non-domiciled domiciled insured, and in relation to a vessel which I'm instructed operated in the UAE waters, so it's an onshore risk. Yes, you have corrected still the submission.
But if the argument is, as I just put to you, it doesn't matter that it's an onshore risk. It doesn't matter whether it's an onshore risk or an offshore risk. It doesn't matter whether Horizon was domiciled in the UAE or domiciled in London, or whether the risk was in Mongolia or in the sea off Dubai.
Yeah, I'm receiving aggressive nods through WhatsApp, and that yes, that is the submission. Yes, my lord.
Okay. Right. Well.
Thank you for indulging me in the time to come to that core submission.
I hope it appears with the same clarity when I reread it all the next morning, which often it does not. Okay, shall we move on?
Yes. Yes. So, my lord, you've already identified where the submission was going, which is that that factual background, that legal background, rather, would have been in the minds of the parties. ABNIC is a sophisticated, large insurer. It would have known that its activities, insurance activities, would have been covered by the mandatory regime under the federal insurance law. It would have known that there was no carve-out applicable in relation to jurisdiction clauses that allowed it to confer a jurisdiction for any disputes on any other court other than that prescribed by Article 110 of the insurance law. Similarly, Horizon either would have been, or a third party in its position as a sophisticated shipping company, would have also understood that regime applied. In my submission, that's an important contractual factor in the contractual construction of the provision, pointing against any choice to confer jurisdiction on the DIFC courts, because the parties have been well aware that was not possible under the onshore regime.
Okay, well, so is that jurisdiction then? We need, I think, to move on.
Yes, yes. You've seen what I say about the various factors Mr. Craig raises in relation to English law and the operation of the courts in English, and the need for consistent interpretations of the institute clauses and other standard form provisions provided for in the policies. What I would say in just relation to that very last point, if I may, and I am conscious of the time, is this. Mr. Craig's submission is that only a court of, quote, with international characteristics, end quote, is appropriate for the determination of disputes arising in relation to insurance policies of this sort with these sorts of standard clauses, because they're based on English authorities, are generally subject to English law, and the DIFC courts apply English, well, law very similar and derived from English law. In my submission, that takes the court nowhere, because there are many thousands of cases, I'm told, proceeding in the onshore courts dealing with marine insurance policies with these types of standard clauses. And there is no commentary that my instructions list has been able to provide, or that ABNIC specifically pointed to, that suggests there is any concern amongst insurance lawyers or the insurance industry that the UAE courts are regularly applying uncertain or inconsistent interpretations of these clauses, or any suggestion that it's only the English courts or courts with laws similar to or derived from English law that are properly able to ensure the consistent and certain application of these types of clauses. And in my submission, Mr. Craig points to the Aberdeen-Daver case. In my submission, what he's asking the court to do is to engage in exactly the sort of jurisdictional paternalism that was rejected in that case by this court, deciding that because it applies common law, it is uniquely or better placed than another court within a common jurisdiction to determine issues arising from these sorts of contracts. In my submission, there's no justification for that in the materials that have been advanced by ABNIC, either in the Court of Cassation decision, which you'll have seen in my skeleton, I suggest has been misrepresented in the evidence presented by ABNIC, or in the general various bulletins that they've pointed to. So in my submission, none of the facts relating to the application of the English language or English law, the need for certainty, point in favour of the DIFC having been a choice of court. The parties knew fine well what the onshore regime was. They knew fine well what law the onshore courts would apply. And as I say, there's no suggestion of any broader concern about the approach taken to or the application of these sorts of policies by the onshore courts. As I think I can probably take the abusive process point, but at more of a canter, because we've explored a lot of them, the points that I was going to make. In my submission, the interaction between the 2004 free zone law and the insurance law, and particularly Article 110, demonstrate quite clearly that this court was never intended to consider any disputes in relation to insurance activities carried on outside the DIFC in the UAE, and that there's been a deliberate attempt by ABNIC to sidestep that mandatory regime, presumably to gain some sort of jurisdictional or legal advantage in this jurisdiction. And in my submission, the timing of the various steps taken is telling. ABNIC was aware at the very latest from November 2020 of the claim. It engaged in 12 months of discussions with Horizon, including discussions involving both ABNIC and Horizon's DIFC lawyers. And at no point during that period did ABNIC once suggest that the DIFC courts have jurisdiction. In reality, what happened is that after the 25th of October 2021 formal claim was served in ABNIC, there was a desperate rush by ABNIC to issue this claim and to issue it first in time. So by the 2nd of November, so 7 days, just a week over after receiving that formal claim. Despite 18 months of review and discussion, ABNIC informed Horizon that it was considering the claim notice and would respond in due course. We now know that was an entirely misleading email, because ABNIC's own evidence is that by the 3rd of November it had instructed Clyde & Co to settle the claim. So there can't be any realistic suggestion that on the 2nd of November it was still really giving any serious consideration to whether or not the claim ought to be accepted. Then on the 7th of November, Horizon filed its claim in the Insurance Authority. On the 8th of November, ABNIC sent a message to the Insurance Authority saying it was considering the claim notice and would reply within 10 days. But again, we know that email was also misleading, because by the 10th of November, Clyde & Co finished their drafting of the claim form, and it was filed on the 10th and then issued on the 11th of November. So my submission is that the whole approach from the 25th of October was an orchestrated campaign conducted with haste to stymie the onshore Insurance Authority IDRC proceedings, and to try to frustrate the enforcement of any judgment from that process by obtaining some sort of res judicata or issue a stop in this court. Mr. Craig raises in his skeleton argument at paragraph 24 various arguments about why there's been no abuse of process. He says it's not an abusive process because the parties have all, I'm not going to advance that point. He says that the Insurance Authority and the IDRC aren't a formal court. You've heard my submissions on Article 110 of the Insurance Law and why that gives rise to a mandatory and integral part of the judicial process within the UAE, and for the resolution of insurance disputes, it can't be avoided, it can't be sidestepped. So the issuing of proceedings is at the very least.
Let me just try and understand this, because I have a feeling that the goalposts have shifted. In your written submissions, the relevant doctrine seems to be lis alibi pendens, whereas the way you're presenting your submission now, it seems to be rather different. Namely, that because of Article 110, the DIFC courts cannot hear this case, and it is therefore an abusive process for them to purport to do so. Is that a correct understanding?
In my submission, those are two linked submissions and perhaps two sides of the same coin. In my submission, it is lis alibi pendens before the Insurance Authority and the IDRC, because, and to addressing Mr. Craig's submission in his skeleton argument that those aren't formal proceedings and therefore can't be lis alibi pendens, in my submission that Article 110 in its mandatory nature means that they are an integral part of the judicial process. Therefore, they must constitute lis alibi pendens, and to issue proceedings in this jurisdiction in order to frustrate them is an abusive process in circumstances where ABNIC knew that they were mandatory.
That is a confusion of the two lines, I think. For lis alibi pendens, both courts have jurisdiction. One gives way to the other.
Well, the abusive process argument, it proceeds on the assumption that this court does have jurisdiction, because in my submission, it can't be an abuse of the court's process of if it's conducting the proceedings. And in the application notices, it is presented in the alternative.
Well, in that case, I think that the two arguments are separate. You have to. I don't think you can. If you are saying that because of Article 110, the DIFC courts cannot hear the case, that seems to be quite a different thing outside the doctrine of lis alibi pendens.
Well, but then in my submission, I can advance it without referring to Article 110. I can refer to Article 110 purely for the purposes of saying that the onshore Insurance Authority Dispute Resolution Committee procedure is required before the onshore civil courts can have can hear a claim related to an insurance policy means that addresses that addresses.
You don't need to say that for this alibi pendens. It's
Well,
enough this alibi pendens for you to say that the procedure under Article 110 has been enlivened.
Mr. Craig's submission is Mr. Craig's submission is that the Insurance Authority and the IDRC proceedings are not court proceedings.
I know, but your argument hear me out. The argument for this alibi pendens is that it is sufficient to say that the procedure under Article 110 has been enlivened, and it is an abusive process for the insurer to then seek to enliven a different process. That does not involve any conclusion one way or the other about whether the Article 110 procedure is the only one available.
I hear what your lordship says, and therefore I won't advance my submission as far as that. The purpose of the submission, the primary purpose, was to address Mr. Craig's written submission in his skeleton at paragraph 24, that there could be no Liz alibi pendants because they were not formal court proceedings. He says that they are a preliminary step, a step before and separate from a legal claim. So if I don't need to take the submission any further, then I won't press it.
Well, if you not too sure where that's left things.
Well, the submission that
as I said, you're saying is that the procedure under Article 110 exists and has been enlivened, and that brings us within this alibi pendens doctrine. I understand that, except I'll ask you some more about it. Is that your argument?
Yes, my lord. I've heard what your lordship says.
Okay, then it does seem to me there is a question properly raised by Mr. Craig about whether this sort of procedure brings in the doctrine of lis alibi pendens, which is normally where the procedure first enlivened is a court proceeding, either within the same jurisdiction or in a foreign jurisdiction. This is not a different court procedure. It is something other than that. I won't say what it is because that doesn't arise in your argument. And it seems to me that I need to ask you then for some authority on whether lis alibi pendens applies where the first procedure enlivened is not a court procedure.
I don't have an authority for that proposition to hand, because my instructions are very clear that as a matter of UAE law, that it is a court procedure or judicial procedure, and I can take you to provisions of the insurance law which reflect the fact that for example, members of the committee are subject to all the rules and regulations and act as judges, and what their competencies are. My submission is that it should be treated as a judicial process, a judicial process akin to a court process, because it is an essential part of proceeding. It is, in my submission, akin to a situation where there is provision made in civil procedure rules for mandatory pre-action alternative dispute resolution, as found in, for example, the English Family Court. You can't issue a claim until you go through a formal court process of mediation. It's not possible.
Well, it won't surprise you that I'm not familiar with the English Family Court procedures.
No, I appreciate that. But I think off the top of my head, I think that's the best I can do.
I think if you wanted, you should have the opportunity to, for example, look for authority that invocation of the English Family Court procedures prior to the actual action is regarded as a lis alibi pendens.
If your lordship would indulge me to make some further submissions in writing, I would be most grateful.
I think that is necessary, but we'll revisit. We will revisit that when I've heard from Mr. Craig. What I'm saying to you is that I think there is a question there, and I don't think your current submissions address it.
And I'm very grateful for that indication. I'm conscious of the time and giving Mr. Craig a full opportunity to address your lordship. Taking two very final sets of points, Mr. Craig suggests that there's, on the assumption that there is a judicial process going on in the Insurance Authority and then the committee, Mr. Craig says that there's no risk of inconsistent decisions because any finding can be challenged before the onshore courts. In my submission, it's perfectly possible for there to be a risk of inconsistent decisions, even if a first instance decision is liable to appeal. And in the meantime, there can still be a risk of inconsistent judgments. Mr. Craig also says that the same issues don't arise in the two sets of proceedings. I say that's not correct. The documents which ABNIC have filed so far in the onshore committee proceedings raise exactly the same issues of substantive, raise the same defences to the claim as in relation to non-coverage by the policy which are being advanced in these proceedings. Equally, if my application fails, Horizon would be perfectly entitled to file a counterclaim in these proceedings, which would again give rise to exactly the same issues being advanced onshore. Conscious of the time, I think those are my submissions, my lord.
Thank you. Well, let me just clarify one thing before calling on Mr. Craig. On one view, a party which seeks a court to strike a case out for abuse of process is asking the court to exercise jurisdiction and is consenting to jurisdiction, which is contrary, of course, to your first limb. I take it that both parties agree that as a matter of convenience, the two questions have been wrapped up together rather than being dealt with one after the other.
Well, that's my position. I don't. Mr. Craig and I haven't discussed that, and I don't believe it's been addressed in correspondence between the parties. I'm sure somebody will speak up if it has.
Yes, thank you, Mr. Craig.
Your Honour, thank you. I mean, just in answer to that question, yes, I think we are content for the two to be wrapped up. It seems as a matter of proportionality, apart from anything else, it makes sense to do it all at once. No. Your Honour, as you know, there are two questions essentially before you. The first is, does this court have jurisdiction? And the second is, if it does have jurisdiction, are these proceedings an abuse of process such that they should be struck out? And I'm going to deal with those in turn. The first question turns essentially on whether the jurisdiction clauses in the two policies satisfy the requirements of Article 5A2 of the Judicial Authority Law. Now, if I may, and I know you're very familiar with all of these things, but I just want to actually look at, first of all, that provision, which is in Bundle D at page 217.
Yes, I have it.
And it is the court of first instance may hear and determine any civil or commercial claims or actions where the parties agree in writing to file such claim or action with it, whether before or after the dispute arises, provided that such agreement is made pursuant to specific, clear and express provisions. Now that is the full extent of the requirement. That, of course, is to be contrasted with the jurisdiction under, for example, 5A1, where there is a requirement essentially for there to be a connection to the jurisdiction between whether it's the parties to the dispute, one or more of them is a DIFC body establishment or licensed DIFC establishment, or that the contract is concluded, finalized, or performed within the DIFC, or it arises out of an incident or transaction which has been wholly or partly performed within the DIFC. Now, that, or rather those connections, are not required and not present under Article 5A2. And the reason I start there and draw that distinction is because a lot of the submissions made by Mr. Hogan were all directed to the absence or apparent absence of connection to the DIFC. And we say that is utterly irrelevant for the purposes of a consideration of the ambit of Article 5A2. All that is required is that there is an agreement in writing that the DIFC court has jurisdiction, and that agreement is made pursuant to specific, clear and express provisions. Now, recently, in the decision of Gale and Credit Suisse, Justice Wayne Martin made clear that that obligation is satisfied, and I can take you briefly to the paragraph where he refers to it. This is in bundle D at page 162.
Yep.
It's paragraph 55. And he says the second consequence arises from the obligation imposed by Article 5A2 to the effect an agreement coming with its terms must contain provisions which are specific, clear and express. However, the authorities in this court to which I referred established this obligation will be taken to be satisfied if the words used by the parties in their natural and ordinary meaning would have been objectively understood by those parties to confer jurisdiction upon the DIFC court in all the circumstances of the case. It follows that once again, the critical issue, proper construction of the words which parties have used in their agreement, if those words are considered reflecting the mutual intention of the parties to confer jurisdiction upon the DIFC courts, the requirements of Article 5A2 will be satisfied. That says the various decisions establishing the natural and ordinary meaning of the words Dubai courts or courts of Dubai includes all the courts established in the Emirate of Dubai, including the DIFC courts, are also very pertinent to the question of whether the jurisdiction agreement contains provisions which are specific, clear and express. So that is, as it were, the starting point for the consideration of the exercise to be conducted. Now, the law and jurisdiction clauses in this case are set out in the two policies. And again, if I may actually take you to them, just so we see the precise wording. First of all, it's A, page 25.
Yep.
And Your Honour will see it, the law and jurisdiction clause approximately halfway down the page. This contract shall be governed and construed in accordance with the English law, and each party agrees to submit to the exclusive jurisdiction of the courts of the United Arab Emirates. Now, this court, the DIFC court, is a court of the United Arab Emirates. Not only is that obvious as a matter of fact, it is also well established as a matter of authority. And if I can, I'm going to take you briefly to the decision of the Court of Appeal from 2015 of Investment Group Private Limited and Standard Chartered Bank. Now that is...
I don't think you need. I don't
Nope.
think you need to. It's well established, and not Mr. Hogan doesn't say otherwise.
No. And the only thing that I would just make clear in that judgment, and it's one I refer to in my skeleton argument, at paragraph 137, the Court of Appeal there made clear that the fact that there is no connection to the DIFC is irrelevant. Now, in a sense, that's unsurprising given the terms of Article 5A1 and 5A2 and the distinction between them. But just to make that clear, that is what the Court of Appeal said in IGPL. Now, in the much more recent decision of the Court of Appeal in Labika and Lardu, this is in bundle D at page 199, and you were taken to it, to be fair, by Mr. Hogan, and in particular the two paragraphs, which I think you already have in mind. Judgment starts at 199, and the relevant jurisdiction agreement in that case was at paragraph 15, recorded at paragraph 15. It's at page 201. Yeah. And you'll see it. It's very similar to what we have here. Save obviously the law is different. The laws applicable in the Emirate of Dubai shall govern this agreement. Any controversy or claim arising out of and in relation to this agreement or breach thereof shall be brought in the courts of Dubai. The distinction here is we're bringing the case in the courts of the United Arab Emirates. And then paragraph 41. It's clear, this is at page 206, clear from what was said in Goal or Gale, ordinary meaning of the term courts of Dubai, capable of meeting the requirement in Article 5A2 for a specific, clear and express provision conferring jurisdiction on the court of first instance. Then it refers to the specific circumstances in Goal or Gale. And then in paragraph 42, in this case, there are no surrounding circumstances to support a construction of the term the courts of Dubai in the contract, which would not apply their ordinary meaning. Consistently with Gale, hold where the parties agree to repose jurisdiction in the courts of Dubai, then absent constructional indication to the contrary, whether from the text of the contract or surrounding circumstances, the term will be interpreted as sufficiently specific, clear and express to confer jurisdiction. So what Mr. Hogan has to point to, and in fact what he's failed to point to, is some constructional indication to the contrary. In other words, that the parties intended not to include the DIFC courts, or it would seem the ADGM, although I'm not entirely sure from that, from the ambit of the expression courts of the United Arab Emirates. Going on in this passage says, the terms specific, clear and express each involves judgment of degree. What is sufficiently specific, what is sufficiently clear, and what level of detail is required. Where a term is used that on its ordinary and unambiguous meaning applies to the DIFC court, the fact it picks up the onshore courts as well does not negate its application, nor does it negate that application as specific, clear and express. The jurisdiction conferred by Article 5A2 is not exclusive, and consistently with that character, the parties can agree to have their disputes determined by the DFC courts or any other Dubai courts. The term courts of Dubai could have been redrafted as the courts of the DIFC and the other courts of Dubai. That would not have changed its meaning. It would be a triumph of form over substance to say the second verbal formula works, but the first doesn't. In this case, of course, there was a surrounding circumstances that the appellants expressly wanted any disputes under the loan agreement to be resolved in an English-speaking court. Now, I'll come on in a second to the further factors which we say point to why it's obvious that the DIFC court was one of the potential jurisdictions for a dispute which the parties chose. But of itself, and looking at the jurisdiction agreements in the policies, we say that as a matter of law, it is clear, and we would say uncontrovertible, that the jurisdiction agreements in the policies include a submission or agreement to submission to this court, the DIFC courts. There is no constructional indication to the contrary. We say that is even clearer when you consider that the jurisdiction clause is to be construed as a matter of English law. And I wasn't sure where Mr. Hogan was going, which is why I referred in particular to the English law authorities, because it seemed that there was going to be a lot of attempt to place reliance upon subjective intentions and what the individuals at Horizon thought they were agreeing. And that, of course, is utterly irrelevant for the purposes of considering what the jurisdiction agreement means. But I understand that is no longer being pursued by Mr. Hogan and the defendants. Now, dealing with the factors which Mr. Hogan says suggest that the parties did not intend to submit to the jurisdiction of the DIFC courts. First of all, the lack of substantive connection of either of the parties to the DIFC or indeed Dubai. Now, there's a factual dispute as to the connection to Dubai, but that doesn't assist the defendants because, as I pointed out when I took you to the particular provisions of the judicial authorities law, it's not a factor to which regard is to be had under Article 5A2. It is just the terms of the written agreement to which you have to have regard. Equally, the fact that the policies were negotiated outside the DIFC or Dubai is utterly irrelevant as well. That doesn't mean that, therefore, the parties must have been taken not to be agreeing to the jurisdiction of the DIFC courts. Similarly, the fact that the insured risk is not present in Dubai or the DIFC is utterly irrelevant. And indeed, it would be rather odd for a vessel that's engaged or supposed to be engaged in trading worldwide to be present in, indeed, the UAE at all, but let alone within Dubai. Now, the big point, or the point which Mr. Hogan seems to major on, is this suggestion that all insurance disputes in the UAE are automatically and mandatorily the subject of regulation by the insurance authority, and the fact that he says they need to go before the disputes committees established under the law. Now, with respect, Mr. Hogan is confusing the regulation of insurance activities with what the parties may agree with respect to dispute resolution procedures. His submission is essentially to the effect it would be illegal or unlawful for an insurer and an insured to agree to DIFC law and jurisdiction. Now, with respect, that is not what the insurance law says, and nowhere in any of those provisions that he took you to is there such a provision. There are certain prohibitions under the insurance law in relation to what an insurer or an insured can or cannot do. And if we may just have a look, if you look at page D227,
yes,
you will see at Article 26, there is a prohibition, for example, on contracting with an insurance company outside the state, state being the United Arab Emirates, with regard to funds or properties situated in the state or to liabilities arising therein. You will also see in at Article 28 at page 227, under this these provisions, it says the insurance policy in the state shall be written in the Arabic language, to which may be attached a comprehensive translation in another language. The policies in this case are not written in Arabic. They are all in the English language. And that's the original policy. There is no translation into Arabic, and Arabic isn't the original document. Article 110 which is at page 242. Part 1 of that, the insurance company shall process the insurance claims according to the legislations in force and the provisions of the insurance policies based on the following procedures. So and then it sets out A to D how a complaint is to be dealt with. However, it's only based on those procedures. And of course, if you have a provision in the insurance policy, which is agreed between the parties, for example, that they can conduct disputes in other courts or elsewhere, then that is the circumstances in which the insurance company and the claim will be processed. There is nothing in these provisions which mandates mandates that in every insurance policy this procedure must be followed. So in terms of background, there is nothing here which says or points to the fact that the parties must, when they issue a policy, or rather when ABNIC issued the policy to Horizon, that therefore they must be intending to exclude the courts of the DIFC or ADGM. And indeed, this insurance law makes no distinction between the DIFC on the one hand, the DIFC courts on the one hand, and the courts in other parts of the United Arab Emirates. So going back to that jurisdiction agreement in the policies, we say the words are clear and express. There is no exclusion of any of the courts of the UAE. And as a point of background, perhaps even more importantly, knowing of the decision in IGPL, which was relevant background to both parties at the time they concluded this, the policies being issued in 2018 and IGPL being a decision which was reached in 2015, if the parties had not wanted to include the DIFC courts, they could and should have expressly excluded it, because they are both taken to know and understand that when you use the expression courts of the United Arab Emirates, you're taken to include within that the DIFC courts. And then the further admissible background, nature of the agreement and context in which the words were used make clear, we say, that the parties intended to confer jurisdiction on the DIFC courts, being a court with international characteristics. And in my skeleton argument, I referred to those factors, the fact, first of all, that the policies are in English, which is the language of this court, the fact the policies are governed by English law, which is a common law system like the IFC law, in contrast to the civil law system operated in the courts of the UAE. It's commonplace for the DIFC court to resolve or be required to resolve disputes governed by substantive laws other than the laws of the DIFC. The policies incorporate a number of standard London marine market insurance clauses developed over a long period of time and intended to create certainty. And we say that certainty is likely to be undermined if interpreted by courts not used to considering such clauses or applying foreign law. Now, in the course of his submissions, Mr. Hogan said there are thousands of marine insurance cases which are proceeding before the UAE courts outside, other than the DIFC and the ADGM. With respect, there is no evidence of that. The only evidence is in relation to cases which are said to be in the Sharjah courts and perhaps other places in the UAE involving my clients. However, with respect, the majority of those are likely to be motor insurance cases, not marine insurance cases. And there's no evidence at all to suggest that there are loads of cases in the UAE non-DIFC and ADGM courts involving marine insurance. So in short, I mean, it is a relatively short point, we say it is obvious and clear that this court has jurisdiction. The parties have agreed to confer jurisdiction upon it by virtue of the jurisdiction agreement in the two policies. And Your Honour, unless you'd like me to say anything further about that, that's, I think, all I need to say.
Thank you. I understand your position, and of course, a lot has been gone through with Mr. Hogan too. So
yes.
Yeah. Right, then abusive process, and here I might say that your submissions also, it seems to me, have not really addressed the point I raised with Mr. Hogan about this alibi pendens.
Well, on that, I mean, there is, no authority has been put our way to the contrary, and we put front and centre of our case the fact that the jurisdiction agreement and normal lis alibi pendens requires there to be other court proceedings, and an administrative process before an insurance committee does not constitute court proceedings, which will be caught by the lis alibi pendens regime.
That may well be right, but unless I have misread something, I don't know that any authority has been cited that confines the lis alibi pendens in that way. And it would help me to know if there is some authority, or am I dealing with it as a matter of principle?
Yes, well, I will look into that. And I hopefully be afforded the same opportunity as Mr. Hogan just to deal with that point. But apart from that, the other points in relation to abusive process, we say it can't be an abusive process to commence proceedings in a court which the parties have agreed shall have jurisdiction.
That can't be right. Let's take it. Let's assume it's a vanilla abusive process. A case is started in Turkey, and then cases started in England because there is an agreement on jurisdiction. The lis alibi pendens doctrine can be invoked in that situation.
But it wouldn't be an abusive process. It would be a forum. That court would then have to basically assess carry out a forum conveniens analysis.
I'm not too sure about that. I think it's a different doctrine. Anyway, I hear what you say, but I don't know that I agree with it. The mere fact that the parties have agreed on the jurisdiction of the challenged court does not seem to me to exclude disallowed indents.
The next point in relation to it is that the ability to bring a complaint is one which only vests in the insured and not the insurer. So the only ability, or the only way in which an insurer can bring a claim, is to start proceedings in the court, wherever that court might be. And one can see that, or one sees that from the insurance authority law at page D251. This is at, if I could ask you to look at Article 4, which is at page 253. You will see it says the committees shall be competent to settle and resolve insurance disputes of all types and classes of insurance arising from the complaints of the insured, the beneficiaries, or the affected of capacity or interest in the insurance dispute against the company. Now, insurance disputes are defined up above in page 252, Article 1, approximately halfway down the definition section. It says insurance disputes, the disputes arising from the complaints of the insured, beneficiaries, or the concerned affected parties against the company. And the company there is the insurer. So there is no outlet for an insurer to bring a claim under any of these before a committee. Its only outlet is to bring proceedings before a court. Nothing mandates an insurer to bring proceedings before a committee, as the defendant suggests. And there is nothing in those regulations to the effect that an insurer is prevented from bringing proceedings against an insured. In relation to the complaints about timing, seems to be one of the submissions made by the defendants, that doesn't assist them because it jumped the gun with regards its submission of a complaint to the insurance authority. And going back to Article 110, the procedure there is that only after the insured has received a response by the insurer should it file its complaint. And in this case, it didn't wait for the response from the insurer before making its complaint. There is also no basis for the contention that a judgment of this court would not be recognised. And again, it's not identified any provision in the insurance law which results in that conclusion. And we say there is none. And then to the extent one entertains and says, well, there are two, if you're persuaded that there are two sets of proceedings, which we say, I've just explained there are not. But to the extent that there are, and it's necessary to entertain forum conveniens arguments, then those factors, we say, favour hearing the dispute in the DIFC court. And those are the same points which I referred to in relation to the background to why the parties would have intended or to have the ability to bring proceedings before a court with international characteristics, namely the policies are in English, they're governed by English law, this court is well used to dealing with disputes governed by substantive laws other than the laws of the DIFC. The London Marine Market Clause points, and it's back to back with the reinsurance contract. So in summary, we say there is absolutely no basis at all for this claim to be struck out as an abusive process. There is nothing abusive about us bringing these proceedings. Your Honour, I'd just check to make sure there's nothing else, but is there anything else you would like me to assist you with in relation to that point?
Thank you. That your position is very clear.
Thank you.
Apologies, I was on mute. I just have a few points very shortly to come back on.
One moment, Mr. Hogan. I think that Mr. Craig is.
Oh, sorry, Mr. Apologies.
I'm just checking to make sure there's nothing I need
Sorry,
to that I've missed or I need to add. Sorry, somebody is typing apparently, so give me. That, Your Honour, there's nothing I need to say further. Thank you.
Thank you very much. Yes, Mr. Hogan.
Yes. First, Mr. Craig pointed to says there's various mandatory provisions in the insurance law. One he pointed to was in, I believe, paragraph 28 at page D227, where he said that all insurance policies shall be written in the Arabic language. Well, in fact, decision number 14 of 2019 of the Insurance Authority Board of Directors expressly excludes marine insurance policies from the requirements being Arabic. So my submission, anything on the face of this law which suggests that certain things are mandatory or not, would need to be checked against the various decisions issued by the Board of Authority. So there's nothing in the point that these policies would be invalid or somehow unlawful, but by virtue of the fact that they're written in English rather than Arabic. Article 26, that in relation to the point that is not allowed to contract insurance with an insurance company outside the state with regard to funds or property situated in the state or to liabilities arising therein. Well, that's just the reflection of Article 4.4 of the Free Zone Law insofar as it relates to the DIFC, which provides that that jurisdiction is related to reinsurance. Mr. Craig says Article 110 is not mandatory because it provides that the provisions in that section are subject to any agreement, the parties might, anything contained in the parties' agreement. Well, if that was right, and Article 110 is not mandatory, and it was possible for the parties to agree alternative dispute resolution mechanisms, or another court or another jurisdiction to determine their disputes, there would be no reason why it was necessary in 2019 for the Insurance Authority to make a specific exception to the jurisdiction of the committees in respect of arbitration. And I promised your lordship that I would take you to that provision. Is it page D253? No, that doesn't seem right. Yeah. Article 5.3 on that page.
Yes, I have it.
And there that expressly excludes from the competency of the committees insurance disputes subject to an arbitration clause. So in my submission, if it was simply possible for the parties to agree to oust 110, the procedure in Article 110, there would have been no need to include this express provision and carve out from the jurisdiction of the committees, because obviously an arbitration agreement is just an agreement for a dispute resolution mechanism. Mr. Craig says that it's significant that there's no ability for an insurer to bring a claim in relation to a policy under Article 110 and associated legislation. In my submission, well, that's just because of the nature of insurance complaints. The definition of a complaint is where a party has filed a claim with an insurer, and that's been declined, and a complaint is then made to the authority and then escalated to the committee. My instructions are that it's perfectly possible, and indeed it's already been done by ABNIC in this case, to run all the sorts of arguments relating to avoidance, ab initio, and a lack of, and where the fact that the claims don't fall under the policies for the various reasons advanced in the claim form, to be advanced in the through the insurance authority and the committees. If there is a procedural quirk, which I'm unaware of, which is that the UAE courts can't grant declaratory relief, well, in effect, if ABNIC were to succeed on those substantive defences, there would be effectively a finding of no liability, which is to like effect as a declaration. And as Mr. Craig pointed out in his skeleton argument, if disappointed with the outcome of the committee's ruling, it is then able to challenge that onshore and would be able to defend a claim for enforcement of the award. So in my submission, it's just the nature of insurance complaints which gives rise to that drafting in the relevant legislation. And finally, on timing, Mr. Craig says that Horizon jumped the gun. Well, I don't think ABNIC can really realistically advance that proposition. The claim form was filed on the 25th of October 2021. The claim was issued on the 7th, and I've referred to the email that was sent on the 2nd of November, in which it was suggested that ABNIC were still considering the claim, but we now know that just wasn't the case. The instructions to Clyde & Co were given on the 3rd. It's quite perfectly obvious that after 18 months of consideration, it had already been decided that no claim was going to be accepted, and indeed no substantive response was going to be given, because these proceedings were being prepared and were going to be issued. So
that was Mr. Craig's point, though. Mr. Craig's point was that for the purposes of 110, it was necessary that there be a dispute because the claim had been rejected, and there was not, because there had not been a response to the claim. That was his point, as I understand it.
Then that was my mistake, and I didn't. If I've misunderstood the point that Mr. Craig was making, then I would not advance that submission. So apologies to Mr. Craig for if there was any misunderstanding there.
I saw Mr. Craig nodding. Let me make sure that I did. I understood what he meant. Am I right, Mr. Craig?
That's precisely the point. Yes.
Thank you. Right.
That's my poor note taking.
All right. Well, gentlemen, I think I would like some assistance, please, on this question of the extent of the lis by pendens doctrine. The question being whether and to what extent it extends to where the other tribunal is not a court, but is some other means of dispute resolution. Let's put it as general as that. The other means, in this case, of course, being via the committee under Article 110. And if you can provide something on that, I would be grateful. I think just independent submissions to me in writing. 7 days, would that be convenient?
Yes, for me.
Sure, that works for me.
Yes. Okay. Well, thank you. We're subject to receiving that. Thank you for your assistance, and unsurprisingly, I will reserve my decision.
My lord, just before you, do you need us to provide you with an order to the effect in relation to those additional submissions, or are you content for no order to be made?
What sort of order are you talking about? I'm just asking you to give them to me.
I know that some judges wish to, in those situations, for a formal minute of order in relation to the directions to be given. I just want to confirm that you're not expecting anything.
And I'm expecting your assistance in that way, and I'm confident we can.
Thank you.
All right. Well, at least for Mr. Craig, it's probably afternoon. It's still good morning for you, Mr. Hagan. So good morning and good afternoon to you both.
Thank
Thanks very
you.
much. Thank you.